So as you probably know, the Species at Risk Act is a very powerful tool that the federal government has at its disposal to protect species and their habitat. And when there is a finding by Environment and Climate Change Canada scientists that the habitat of a species is not adequately protected, I have the legislative obligation to go to Cabinet and recommend that an emergency order be put in place to protect the habitat of said species. Now, Cabinet has obviously the liberty of deciding whether or not this emergency order should be put in place, or whether or not an alternative scenario should be explored, like negotiating with the province, in that case the government of British Columbia, and that's what's been happening on the spotted owl. We have been working very closely with the government of British Columbia on spotted owl recovery. We've been working with Indigenous nations in British Columbia on this. You may recall that we signed an historic agreement, the first of its kind in the country, a tripartite agreement worth about $1 billion between the nations of the Indigenous nations of British Columbia, the province, and the federal government. So we're doing a number of things to try and ensure that we can protect the habitat of all species. We have a lot of work to do, obviously, and since that court ruling was just issued, we will obviously be looking at it very closely to see how we need to respond. We have, in fact, in some instances, issued emergency order to protect certain species where we felt that negotiation with a province was not possible, or we had tried that and it didn't work. So it's not we take these decisions are taken on a case-by-case basis. It's not one size fit all. The situations vary greatly across the federation and across species as well.